SJC-11308, Commonwealth v. David Jackson.
All right, let's proceed.
Morning, Your Honors. Attorney Alan Black for Mr. Jackson. And I would ask, please, for 1 minute for rebuttal, since I believe this is a 10-minute argument. Your Honor, this is a case that's before you on a 33E review, and Justice Botsford was the gatekeeper. This procedural history in this case has been described as convoluted, and I believe that's correct. If we spent our time going over it, it would take us all day, except that some of it is relevant. I just want to say to the court that the status currently is that it's stayed in front of Judge Young in the federal district court. It's been stayed before Judge Young since 2009. He wrote an opinion saying that he was troubled by certain things that he found based on his discovery order that was supplied by the Commonwealth late in the game. But this is a 1990 incident that went to trial in 1993. And there was one witness, one witness that places the defendant at the scene, and Mr. Olbinski. And the issue is a Brady issue. And it's simple as that. There was much discussion at the trial about rewards, promises, and inducements. It was a very strong subject of an opening and closing argument by the prosecution, who said to the jury, if there was anything, I would have told you of it. And there isn't anything. There are no promises, no rewards, no inducements, except for the fact that by the efforts, essentially, of the defendant, who after a trial, after an appeal, after an initial habeas, after a second motion for new trial, after an appeal, after, well, I was going to say a second habeas. It's actually not a second habeas. Judge Keaton actually ruled on a Rule 60 and said, I'm not going to rule that this is a second habeas because I was troubled by it, and ruled on a Rule 60, which basically said I'm going to reinstate the first habeas, and didn't call it a successive petition. Justice Keaton died. Judge Young took over the case. He ordered some more extensive discovery on it, and after he ordered the discovery, which was a deposition of two judges, two sitting judges, Judge Phyllis Boker and Judge Coffey, who were prosecutors at the time. Judge Boker was the one who originally dealt with this person, Olbinski, and Judge Coffey was the one who tried this case, but said he got into the case 3 weeks before the trial. The deposition, and I don't know an artful way of putting this, but the deposition of Judge Boker was troublesome. She didn't remember anything about the case at all, and she kept on getting prompts by the defense attorney at the time, who was Attorney Kempthorne, who I took over for. This was a person who was not a citizen of the United States, who had a quarter-of-a-pound case in Oregon on methamphetamine that they found, who was released by the Oregon authorities with a letter that was discovered in this last round of discovery, a note from Attorney Fong, who was the attorney in Oregon, that said, I got contacted by the prosecutor, and I was told to treat this person nicely. And it's this Oregon transaction that troubled Judge Young. Judge Young actually denied the habeas on the bail argument, the fact that he was released on bail, and he still had this meth case going. He said, I'm denying it on that issue. But what he ordered us to do was to exhaust all the state remedies on the Oregon issue. And
I just wanted to know if you could help us sort of focus on what evidence there was of actually an agreement between the Commonwealth and Olbinski.
Well,
When Olbinski's lawyer says there was no agreement, or apparently would have said if called that there was no agreement?
it's not so clear, because we have Olbinski's lawyer who initially said that, that he was not, and I think this was Rovario, who
That's
said,
the Oregon lawyer.
the Oregon lawyer.
Yeah, I'm talking about the lawyer who represented him in Massachusetts.
He said that he wasn't, this was Ruby, I believe,
Yeah,
attorney.
and Ruby, if called, apparently, defense counsel told, I don't remember which judge, I think it was Judge Brady, that if called, would say that there was no agreement.
Except that's not what he initially said. What he initially said, and I believe this is in an earlier Attorney Kempthorne affidavit, that he said that he was told by Olbinski that the ruse, the quote ruse charge in Massachusetts was just a way to get him there, that he knew that there was no real charge in Massachusetts, and that was not going to happen. Now, what Attorney Ruby initially said was, I didn't believe this, because clients tell me a lot of things. But he had contacted Attorney Rovario in Oregon, and he confirmed that. And then he said, well, that must be true. And I think another argument about this was, here we have a man who's charged with first-degree murder in the Commonwealth of Massachusetts. He comes out here on his own. Then Attorney Coffey, Prosecutor Coffey, calls him without an attorney present. And I believe the argument that we made was, you don't call a witness cold without having his lawyer there, without having some kind of agreement with this attorney that he's not going to take the fifth while the jury is there. It just doesn't happen that way. What happens is there's much discussion with counsel for this particular witness, and things are hashed out ahead of time. Because the risk is, if you call this witness cold without discussing it with counsel, is he's just going to get up there and say, I take the fifth. How would he have known that he wasn't going to do that without a discussion? He knew. And of course, he didn't assert his Fifth Amendment rights. He didn't have a counsel present, I believe, at the trial. He just got up there and testified. And
where was Mr. Ruby? Where was Mr. Ruby?
I don't know.
Was there any suggestion that Ruby was being bypassed by the Boston police in dealing directly with Olbinski?
No, no indication that that was going to happen. But the argument that was made is that there had to be some kind of knowledge by Attorney Coffey that he was going to call this person in. No Fifth Amendment was going to be asserted, and it wasn't. It was never on the record. He was just immediately called. And it's also interesting is that he's brought from Oregon on a warrant. Then he's let go on, he has a quarter-pound meth case in Oregon. He's brought here. He's let go here on a bail that was not disclosed, although I think Judge Young ruled that due diligence could have discovered that part of it. But he's let go on bail with a bracelet supervised by the Norfolk County District Attorney's Office, and nobody's quite sure how Norfolk County got involved because this is a Suffolk County case. So he's supervised on a bracelet and then let go. While he has a murder case here, which coincidentally enough, 2 weeks after the trial in our case, the murder case is dropped. And then he goes to Oregon, eventually, I think it took him a year or two. Then he goes to Oregon, and that case is dropped.
Well, so it's 20 years later or so.
Yes.
There's been a lot of discovery. I mean, when you think that this is a criminal case, an incredible amount of discovery. And there seems to have been no evidence. I mean, you have disbelief of, how could this be? But that's sort of what you got, isn't it?
No, I think I have more than disbelief. I have a note by Attorney Fong that says, I have been advised, and it's in the appendix.
No, I know that.
I've been advised, and I know you know that, Aaron, I'm sorry, but it's
No,
been
no, I'm
advised
sorry. I didn't mean to.
that we are to treat this particular person nicely. Now, that's not what, we did not have that before. And we were asking Judge Brady for an evidentiary hearing so we could flush some of these out. He allowed these depositions. limited. He didn't allow depositions on the police officers. He allowed a couple affidavits and then a deposition on one of the officers, Officer Rogers, I believe, who didn't refuse to do an affidavit. So there was a deposition, and all three officers said, "I don't know anything. I never talked to him."
Mr. Black, your time.
I know, Your Honor. I'm sorry.
Coming back.
I am.
We'll hear from you again.
Thank you.
Good morning, or good afternoon. I'm sure quite what it is right now. May it please the Court, Paul Lynn for the Commonwealth. There have been no significant changes in this case since this court last upheld the defendant's conviction in 1997. The only new information we have is the so-called bail agreement, which was simply that when Olbinski was released, he was to be on a bracelet. And that
Is that, I mean, part of the thing is that, you come away with this and you feel like even if like the individual pieces of information may not have developed that greatly, the tableau, the picture seems to change. And was it really sort of known that there was the possibility that the murder charge itself was a ruse to keep Olbinski out on bail? It's easier than just trying to have gotten him as a material witness from Oregon. I don't know what difference all of that makes, but I mean, I'm not sure that was sort of so obvious as of the time that the court ruled on the direct appeal.
this is the information this court had in 1997, that Olbinski was not being held when he testified, that he had been released on $5,000 bail, that his charge was dismissed 2 weeks after the defendant's trial. All of this information was known to this court in
But
1997.
no one knew that there was a plan to treat him nicely.
I would like to comment on that. The evidence is that a Massachusetts authority, and the Commonwealth doesn't dispute that this was done. No one remembers who it was or when it was, but it's clear from the Oregon records that some Massachusetts person involved in the case called Oregon and said, please withdraw this warrant, because we don't want this witness going back to Oregon. The part about treating the defendant nicely, if you read that note, says, apparently, we're supposed to be treating this defendant nicely because he's a material witness in a murder case in Massachusetts. So there's no evidence that anyone said, treat this guy nicely. They just said, withdraw the warrant, please. The treat him nicely is an inference that was drawn by whoever wrote that note. It appears to be DDA Fong, but it's not clear.
Did the, I forgot his name, Raviola?
Yes.
In Oregon, did he overstate the existence of any agreements between Boston and Oregon?
Absolutely, he did. And he admitted this in his affidavit. When he spoke at the sentencing hearing in Oregon, he said, oh yeah, the police lied to the grand jury and they called DDA Fong and asked him to withdraw the charges. And when he actually provided the affidavit, he said, no, I didn't. This was something that I think I heard from Attorney Ruby years ago. And I didn't actually hear from the Massachusetts authorities, and DDA Fong contacted the parties. This is in the Commonwealth's appendix, and said, I certainly don't remember this, and I wouldn't have done it in light of the facts of this case, even if they had asked me to reduce these charges.
Is there anything in the record that sheds some light on why Attorney Ruby seemed to have sat back for a couple of years in defending this case? He filed his motion to dismiss. He filed the McCarthy motion, and let it sit. I mean, that takes a lot of confidence, maybe even more than confidence. In fact, if he had the confidence, you would have thought that he might have pursued the motion to dismiss earlier. What does the record show about that?
Well, the defense has not produced an affidavit from Attorney Ruby, who is available. But what we do know from the affidavit of Attorney Kempthorne is she called Ruby, and he said he was always confident. I've got the exact language here. He wasn't worried because he knew that Olbinski was never more than a material witness in the case. So that's why, as the Commonwealth stated in its brief, there was no need for a deal. I mean, there was no deal because there was never any need for a deal.
Was the pendency of the murder indictment an accommodation to Olbinski, who I take it might have been deported?
There's no evidence that Olbinski was subject to deportation, even now. I've no evidence whatsoever. Matter of fact, it came to light during the pendency of this motion that he was back in Massachusetts, which I informed defense counsel of. So I don't think there's any significance, any evidence whatsoever of deportability here.
Mr. Lynn, how was, I apologize that I don't know this more thoroughly, how was this witness handled at trial with respect to cross-examination on bail, pendency of charges, et cetera, et cetera?
He was not questioned about the bail, which defense counsel knew of at the time. Certainly was raised in his first motion for new trial. And the apparent reason for that, as this court found in 1997, or ruled in 1997, was defense counsel wanted to paint Olbinski as someone with his head in the noose, who would say anything to avoid being prosecuted for first-degree murder. So he had a very strong strategic reason not to bring out this evidence, because any evidence that the Commonwealth was not intent on prosecuting Olbinski would actually bolster his credibility as opposed to hurting it.
Thank you.
Yeah, I would point out just one thing that my brother said. He has it backwards. It was Raviola who called Ruby. What happened was Olbinski, according to Raviola's affidavit, Olbinski said he wasn't worried about this Massachusetts charge. And Attorney Raviola was very concerned about that, so he called Attorney Ruby, and Attorney Ruby backed him up and said, yeah, this is not a charge that we're worried about. He's more of a material witness than he is a defendant.
Doesn't that strike you as just an odd thing? You know, we're not, so that the lawyer would just, Ruby would be content with, okay, so he's facing a murder charge, but it's not really a murder charge? And without having spoken with somebody from the Commonwealth, that you would have at least an implicit understanding that this is not a real murder charge? And you're only just doing this on the basis of your own evaluation of what you think that the Commonwealth has, as opposed to, you know, no guarantees you're going to get the thing dismissed. You think you probably will, but that's a different calculation. You'd protect your client's interests as long as that murder charge is pending, wouldn't you?
Well, he filed his motion to dismiss very early in the proceedings.
Nothing happened, and so his client is testifying, and they're not worried about him testifying, and they're not worried. It just... how that happens without some conversation or understanding with the Commonwealth is what is the troubling piece here.
I can't comment on that. There's nothing on the record. There's no affidavit from Attorney Ruby. The trial prosecutor doesn't remember it, but Attorney Broker doesn't remember it. It's 20 years later. There certainly is no evidence that the prosecutor gave Attorney Ruby or Olbinski any assurances that he wouldn't be prosecuted. But if you read his motion to dismiss, it's very clear. The grand jury minutes, although they're missing, it's clear from the trial judge's decision allowing Olbinski's motion to dismiss that all it was, as was the practice at the time, the detective came into the grand jury and recited what Olbinski had told the detective. And that was the same story he told 2 months after the murder or 3 months after the murder when he was indicted and then at trial, is that he took the defendant and Mark James to the drug house, but when he realized they were going to rob the drug dealer, he said, I'm leaving, you're on your own.
Why did it take almost 2 years to get the indictment?
I don't know.
I mean, it was a simple case.
Oh, no, excuse me, it's the indictment. I was thinking the motion to dismiss.
Yeah.
The indictment is, and that's another point in this case, is this case went nowhere until Perkins and Barnes and Vick come into the case. These are the three witnesses in Mission Hill who gave the information and testified at trial that the defendant and James came to their house after midnight on the night of the murder and said, we just made a big score in Brighton, and the gun went off accidentally, and I think somebody's dead, and all of that information. That was what brought this case from just an investigation to an indictment. Because without that information, all we had was the defendant showing up at the drug house and then, a victim. And it wasn't until we had this corroborating evidence from Vick and Barnes and Perkins that the case went forward. And that's another reason why this was harmless. The first reason is, as this court held in 1997, even if all of this evidence had been disclosed to the defense, and as I pointed out, almost all of it was, defense counsel had no reason to bring this to the jury's attention because it would have been counterproductive. And the second reason is any further impeachment on the margins that counsel possibly could have accomplished regarding Olbinski did nothing to negate the testimony of the other three witnesses, also the testimony of the men in the first apartment, that these two men who matched Olbinski's description came in and tried to rob them.
So you don't think it would have made a difference from a trial strategy point of view if there had been some reason to think that Olbinski was being protected by the Commonwealth in order to be able to come to testify, and that maybe you wouldn't have then said, well, you know, his head is in a noose, but you would be taking a different tack saying, you know, this guy is in the bag for the Commonwealth?
As this court has already held, that would have
I
been,
know that we
would have
held
been
then.
less compelling than the evidence that his head was in the news. Yeah, he's friends with the Commonwealth. This court has repeatedly held that it's more compelling that the defendant is facing, or the witness is facing pending charges than he has been relieved of previous charges.
Counsel, your time is up.
Thank you.
Thank you.
Just two very quick points on two separate issues. Yes, they waited several years. Yes, the McCarthy motion was filed. Yes, it wasn't acted on until 2 weeks after. Yes, the prosecutor never even argued the McCarthy motion, just said, I submit on the transcript. Attorney Coffey said, well, usually I would argue and then submit on the transcript. He did not argue. Not only was this man, who was not a citizen of the United States and had a quarter-pound methamphetamine case in Oregon, let out on a $5,000 bail on a first-degree murder case, which is, I would argue, is unheard of. He then goes back to Oregon eventually on his own and has that quarter-pound methamphetamine case dismissed by Mr. Fong. And there is that note, and the court has it, you can read it, that says, the nicely part. Just the last thing I want to say is, under Tucheri in this court, there has to be a reasonable likelihood that the false testimony could have affected the judgment of the jury. Yes, there's these corroborating witnesses who weren't there, and they testified that they were on cocaine the entire day. And these are the, quote, corroborating witnesses. All we have is this Mr. Olbinski, who said he dropped the client off, client had a shotgun, and he left. That is the evidence in this case.
Thank you, Mr.
Thank you very much.